Hello and welcome to this Federalist Society webinar. This afternoon, Tuesday, August 6th, we have a webinar on the federal and state enforcement perspectives on SFFA and DEI programs. My name is Ryan Lacey, and I'm an Associate Director with the In-House Counsel Network at the Federalist Society. As always, please note that all expressions of opinion are those of our experts on today's call. Today, we are fortunate to have an excellent panel moderated by the Honorable Sharon Gustafson, whom I will introduce very briefly. Sharon Gustafson has been in private practice for 33 years, starting at Jones Day, except for a brief stint as General Counsel of the U.S. Equal Employment Opportunity Commission. After our speakers have given their opening remarks, we will turn to you, the audience, for questions. If you have a question, please enter it into the Q&A feature at the bottom of your screen, and we will handle your questions as we can towards the end of today's program. And as a reminder to any attendees who are seeking CLE credit, we'll be posting a CLE code in a chat box at some point during the presentation. Write this code down because you will be required to provide it at a later time when completing your certificate of attendance. With that, thank you for being here today. Ms. Gustafson, the floor is yours.
Thank you. Happy to be here. Paul Watkins is the managing partner at Fusion Law. He previously oversaw civil rights enforcement as the Civil Division Chief in the Arizona Attorney General's Office. Sarah Pineau is of counsel at Fusion Law. She is an experienced employment attorney who previously practiced at Polsinelli and Jones Day. Thank you for being here. I'm going to briefly give you a little overview of what we're going to do today. We're going to talk about federal and state employment discrimination law, the background on that briefly. And then we're going to talk about its applicability to the Students for Fair Admissions case. And then we're going to discuss some common DEI practices, race and gender composition goals, and race and gender-based fellowships and training programs, mandatory DEI training, and diversity interview slates. We hope to get to all of those. First, for a little bit of background on federal anti-discrimination law. The U.S. Constitution's Equal Protection Clause states that no state shall deny to any person with its jurisdiction the equal protection of the law. We start there. Of course, that applies to government actors only. And any encumbrance to equal protection must be subject to strict scrutiny. That is, it must further a compelling governmental interest, and it must be narrowly tailored to achieve that interest. Before the SFA case, in the university admissions context, the Supreme Court allowed limited consideration of race in higher education admissions. As for the federal statutes that are relevant, under the Civil Rights Act of 1964, we have Title VI, which prohibits race, color, and national origin discrimination by entities that receive federal funds. And then we have Title VII, which prohibits race, color, religion, national origin, and sex discrimination by employers. And it protects all races from discrimination in the terms, conditions, and privileges of employment. In addition to employment practices, and that covers both intentional discrimination and disparate impact discrimination. There is a prohibition against discrimination in training programs, in job notices and ads, and that sort of thing. And terms, conditions, and privileges of employment covers everything, not only hiring, but also transfers and that sort of thing. Title VII requires an exhaustion of administrative remedies before the EEOC, and typically employees have to get to the EEOC within 300 days. Title 42 USC section 1981 also prohibits race discrimination, including in employment relationships. But unlike Title VII, section 1981 covers only race discrimination and not the other categories of discrimination, and it covers only intentional discrimination, not disparate impact. There's no administrative requirement for filing a section 1981 claim, and there's a 4-year statute of limitations. The EEOC can initiate lawsuits against employers, and both individuals and state attorneys general can bring claims under Title VII and Section 1981. And with that very brief background of these statutes, I'm going to turn the discussion over to Paul Watkins to talk about state anti-discrimination laws.
Well, thank you very much, Sharon. As was noted, state attorneys general have parents patria authority, so they can enforce Title VII as well. And this has been commonly utilized by states like New York and Massachusetts. Of course, states have their own equivalent of Title VII. Often these state statutes apply to smaller entities, and they also have sort of idiosyncratic provisions. Michigan, for example, covers height, weight, and marital status. There are also states with significant exceptions or gaps, particularly if you're looking at the Southeast. A state like Alabama actually does not have any state equivalent for employment discrimination. The tests under state law are usually very similar for Title VII and 1981. One important characteristic is that the enforcement often flows through a human rights commission that is separate from an attorney general's office. So when I was in Arizona enforcing civil rights laws, we had direct enforcement authority. That's actually somewhat unusual at the state level. So now I'm going to turn things over to Sarah to continue the discussion.
Students for fair admissions, Harvard and UNC were giving racial preferences in their admissions policies, and that really wasn't the debate. The debate was whether these racial preferences were permissible. And the court rejected the school's argument that diversity-related interests justified the school's use of these racial preferences. Now, notably, although this was a higher education case and didn't directly address employment, the court really laid the foundation for an extension to the world of employment law. So the court said racial discrimination is invidious in all contexts. Eliminating racial discrimination means eliminating all of it. And Justice Gorsuch, in concurrence, laid the framework for extending this from Title VI to Title VII. So although the court focused its analysis on the Equal Protection Clause, it said that violations of equal protection are coextensive with Title VI. And Justice Gorsuch pointed out, well, the anti-discrimination language in Title VI is identical to the anti-discrimination language, essentially identical, in Title VII. So Justice Gorsuch said we should interpret the same terms in the same way. So this can be extended to Section 1981 because although that statute is different on its terms, courts typically analyze Title VII claims in the same way as Section 1981 claims. And a number of federal district courts have latched on to this sort of broad application of students for fair admissions. So in Ultima Services, the Eastern District of Tennessee expressly said, there's no indication that this is limited to college admissions. Texas District Court said the same thing. And then recently, the Southern District of New York applied students for fair admissions in the context of a city employees discrimination claim. And then recently we have the 11th Circuit Fearless Fund case, which was a Section 1981 case and didn't expressly rely on students for fair admissions, but it's pretty clear that that case, which prohibited discriminatory contests and grant programs, is a logical extension of the court's reasoning in students for fair admissions. So another argument for extending students for fair admissions outside of higher ed and into the world of employment law is that it's in line with prior Title VII cases. So most of this court's jurisprudence on affirmative action, as you likely know, developed in the context of higher education and federal contracts. So there aren't as many cases in the private employer Title VII context, but from the cases we have, the courts were saying that diversity is not a recognized Title VII objective. Third Circuit said that in this Taxman case. And then similarly in the Schur case, the court said that a private employer's affirmative action program that was non-remedial and sought to hire a minority candidate instead of a non-minority candidate expressly to achieve a percentage goal violated Title VII. So in both of these Third Circuit cases, the court is analyzing these affirmative action plans in the context of Weber, which is the key Supreme Court decision here that Paul's going to discuss.
So Weber, I think it's important to understand two things. One is the factual context and how narrow these facts are. And then second, to take a look at the reasoning and consider that in light of SFFA. So in Weber, you had less than 2% of the workers at a plant were Black, 39% of the workers in that area. So the eligible worker pool was Black. So massive disparity that came from very specific discriminatory policies that were and practices that were in place. And what the court did to reach the result is take a somewhat non-literal view of Title VII and to say we'll allow these temporary programs that have purposes that mirror the statute. And here's the key phrase, really: do not unnecessarily trammel, whatever that means. Unnecessarily is doing a whole lot of work there. The interests of non-minority employees. So in addition to thinking about the facts, it's probably today going to be somewhat unusual for a company to have facts that fit this scenario. Also, if you read the Rehnquist dissent in this case, it sounds a whole lot like SFFA. So the reasoning is something I would not want to be up at the Supreme Court saying Weber means that I win. Let me just put it that way. There is, of course, considerable debate on the application of SFFA in employment, big disagreements between Republicans and Democrats. The Republican AGs wrote a letter to Fortune 100 CEOs. The Democrats responded with their own letter. The Democrat letter is very interesting to me. They're justifying they're defending a lot of DEI practices around eliminating barriers, which is a concept that I think we'll get into a little bit more, and trying to say that these targets do not necessarily equal quotas, which is something that may be a little bit more accurate in theory than practice. But if you read the Democrat letter, it's very careful. They're not, they make a lot of qualifications in that letter in order to avoid, I think, justifying all practices that companies are engaged in. There's a similar dispute around letters to the ABA. And of course, this dispute is also occurring at the EEOC.
Yes, at the EEOC, the chair, Charlotte Burrows, has criticized the SFFA opinion as inconsistent with precedent. And she has said that it fails to take into account the benefits of diversity to companies. And she has said that DEI programs that seek equal opportunity are still lawful. EEOC Vice Chair Jocelyn Samuels has said that DEI initiatives are distinguishable from race-based admissions in SFFA. She has defined the DEI as expanding recruitment activities to attract a broader applicant pool, tracking the effects of employment decisions on different groups of employees and then publishing the results, and establishing employee resource groups, among other measures. EEOC Commissioner Andrea Lucas has said that SFFA did not alter employment law because the court has never allowed workplaces to take race-conscious employment actions based on workforce diversity. She called SFFA a wake-up call and said there's never been a better time for companies to take a hard look at their diversity programs. And she noted that SFFA heightens employers' practical risks by rejecting common DEI justifications, such as benefits of diversity. In the Roberts v. Progressive Preferred Insurance Company case, the EEOC submitted an amicus brief in which it said that the SFFA did not alter the standards for voluntary affirmative action by employers. And it said that Section 1981 incorporates the same affirmative action standards as Title VII, And SFFA did not alter those standards for private employers. And talked about that Roberts case. We've already talked about it, what it had to do with, so I won't go into that. Well, maybe we didn't. There was a company that was giving $25,000 grants to 10 Black-owned small businesses to use towards the purchase of commercial businesses. And somebody who didn't fit into that category complained that he was being discriminated against. That's what the case was about. The EEOC reiterated in its brief that Title VII permits private employers to adopt voluntary affirmative action plans to remedy manifest imbalances. And they continued to apply Weber. And I just want to note here briefly that there's a tension between Title VII explicit statement that no affirmative action may be required, but it doesn't say whether it can be permitted. The tension comes in between it saying that under Title VII, it's illegal for an employer to fail or refuse to hire, discharge, or otherwise discriminate based on race, while also saying that employers may voluntarily use race-based affirmative actions in hiring and promotions. And so the tension is, how can those two things happen at the same time? And now I'm going to turn it back over to Paul to talk about Attorney General enforcement actions.
So within this dispute, the Republican AGs have started filing lawsuits. And to some extent, I guess this resolves the issue, because if there's one group of AGs saying this is fine and there's another group suing over it, then you probably got to pay attention to the group that's suing. So the Florida Attorney General filed an administrative complaint against Starbucks a couple months ago. Starbucks had a goal of achieving BIPOC representation with specific percentages at both corporate levels and retail and manufacturing goals. And Florida says this is discrimination based on race to hit these quotas. This is against our law. And so here they're going through the Human Rights Commission again, because some of this somewhat quirky structure that exists at the state level. Missouri filed a lawsuit against IBM, and this was based in part on CEO testimony saying that executives are required to increase percentages of certain demographics by 1% each year or lose part of their bonus. And again, the AG is saying this is a quota, this is unlawful. Now, I think we want to shift gears a little bit after giving you that background of the law and what's going on, and we want to talk about specific practices to try to make this concrete. So we want to talk about composition goals, preferences and job notices and advertisements, goals in hiring promotion, executive comp, fellowship programs, DEI training, and then interview slates. So here are some examples of common composition goals that companies put on their website, similar to what you just saw from Starbucks. So this is a tech company. We've committed to doubling the number of Black and Hispanic employees in the US. We've met that goal, we've exceeded it, and we're looking to build on those percentages. Here's a soft drink company. By 2030, our employee population across all job levels will hit these certain percentages in line with the census. Interestingly enough, their target for Asians is 6% by 2030. Asians are currently 7% of their companies. So very similar facts to SFFA. We're seeing that when you target specific racial composition, that's going to hurt somebody, which again was part of the reasoning in the majority of that opinion. So what legal provisions are implicated? Of course, Title VII says it is an unlawful practice to discriminate. And as Sarah had noted earlier, there was a DC circuit case, a longstanding circuit case that says there's really no difference. You can call it a hard quota, you can call it a soft quota, you can call it a goal. If you're trying to hit a numerical target, that's a quota, that's unlawful. Another provision that companies may not be thinking of is that there are very broad prohibitions on expressing preferences in advertisements relating to employment. So not just the job notice, but the diversity page, the career page, all these pages around employment. there are specific prohibitions here. And the EEOC has taken a very broad interpretation. In fact, there's a famous case against McCormick and Schmicks where the EEOC said, hey, all the pictures on your website were all the same race. So you're expressing a preference. Well, here you have companies saying, we're trying to hit these numerical targets for specific races. Seems like that's probably more of expressing a preference than just having photos. And in fact, some companies in the job notice have expressed preferences for non-white candidates. There's a lawsuit against King and Spalding for that type of notice. Another area where this comes up is in employment compensation. Here's a company that's fairly typical. Our incentive program includes a commitment to diverse representation. We tie compensation to employees' ability to build diverse and inclusive teams. Here, the liability for the employer is not reduced simply because you're asking an executive to engage in the conduct. It's very clear law that supervisors, employees, they act on behalf of the company. If the company can't do something, the executive can't do it either, and that accords with the reasoning in SFFA. So we thought it'd be helpful to throw out some case studies that are based on actual litigation, actual decisions, or ongoing litigation. So here's a case study related to some of these targets. We got a company saying, here's our philosophy. We have a general DEI philosophy. Our teams should reflect our communities. Leadership should reflect our teams. We have targets. We don't have quotas, but we're going to tie bonuses to achieving these composition goals. White male executive is terminated. Of course, there's a dispute about whether this is for performance or not, replaced by a racial minority. So what are some of the considerations? What are some of the facts here? This case comes out of the Fourth Circuit. Plaintiff brings a Title VII mixed motive claim. Again, remember, race does not have to be the primary factor. It's unlawful if it's any motivating factor for an employment decision. District court denies summary judgment, 7-day trial. Jury awards back pay and front pay plus $10 million in punitive damages, which is pretty substantial. Now, that is later reversed on appeal at the Fourth Circuit. But the Fourth Circuit panel found there was more than sufficient evidence for a jury to determine that race or sex motivated this decision. And here are the facts, and I think they're worth considering because there are a lot of companies that have put themselves in a similar factual position to this defendant and have created, therefore, I think, similar risk. So the company had a wide-scale D&I initiative. They, of course, showed increase in certain percentages, decrease in other percentages of employees, tied bonuses to racial goals. And of course, there's going to be conflicting testimony about performance. And there were instances of other white males being replaced by minorities. This is in the Fourth Circuit, which I think most people would consider one of the probably left-leaning circuits in the country, and still came out against the defendant. So now I'll pass things over to Sarah for fellowship programs.
Yeah, another common DEI practice that we see, and if you've worked at a law firm, you've probably seen something similar to this, is a fellowship program or a training opportunity that's expressly limited to certain races or sometimes to certain sex or genders. An example is Black Leaders for Tomorrow program. That's a real example. Another is this RISE program that we have quoted here, which is it's a development program. So it's giving access to networking and growth opportunities only to certain races. I think you can move to the next one. Title VII actually expressly prohibits discriminatory training programs. Most cases aren't brought citing this section. A lot of times they're brought as a privilege of employment or just a general discrimination case. This recent DC case says expressly that training opportunities can be a privilege of employment. And if you're denied that based on your race, it can be actionable under Title VII. So a case study on this is a company that states eligible applicants for a diversity fellowship must be members of historically underrepresented groups in the legal profession. And they define that. They said, it's color, students who identify as LGBTQ+ students with disabilities. And they also defined diverse, which is important because what we're seeing now is a lot of companies playing around with the way they define diversity. In this case, it was just a pretty clear race-based criteria, and then also LGBTQ+ and students with disability. So this fellowship program is paid, and it includes mentorship and a promise of employment upon completion. Now, this is shortly after Students for Fair Admissions and the American Alliance for Equal Rights challenged this type of program at two major law firms. They challenged this as a Section 1981 violation, which is, again, the discriminatory employment contracts. And the firm's express statement that this is limited to certain races is pretty direct evidence of discrimination. Now, we didn't have the benefit of a court opinion in these cases because the law firms settled pretty quickly, which I think says a lot about their fear of the liability here. Essentially, there was a stipulated dismissal entered shortly after these cases were filed, where they agreed not to ask about race and to remove any sort of racial criteria. So even firms like Perkins Coie, which was one of the firms sued, originally pledged to fight this and then realized it was likely a losing battle. So these cases are interesting. They happened fast after Students for Fair Admissions, and I think it shows that there is certainly some merit to these lawsuits.
Another common practice is mandatory workplace training, and so we have litigation related to this as well. So in this scenario, there's a company that requires attendance at several conferences. So these conferences are outside the company, but they're required, at which there are negative traits described to white people because they're white. Emails from colleagues saying white people should feel terrible, suggesting videos that maybe have similar language. This is probably going on, I think, around George Floyd in 2020. Employee complains and says these trainings and interactions are creating a hostile work environment for me. So this is an actual piece of litigation brought against Penn State University, and the court denies the university's motion to dismiss, says professor has alleged a pervasive racial harassment. And of course, the test for hostile work environment is severe or pervasive. Usually people allege both. And so what the plaintiff's alleging is that these DEI trainings plus negative interactions based on race is creating this kind of environment. And there's an interesting quote from the court here. When employers talk about race, any race, with a constant drumbeat of essentialist, deterministic, and negative language, they risk liability under federal law. So discovery is still ongoing in that case. Similar example, I think we have time for two examples on this point here. And this is interesting because it's in New York State Court. So the leader of this organization testified that its policy was to have high-level leadership reflect the diversity of the city. Diversity and equity was a priority. Equity training sessions, again, with similar material, disparaging comments about whiteness. And then you've got some employees being replaced by employees of a different race. Court denies summary judgment to the defendant, City of New York. They settle. Southern District of New York case, again, Second Circuit, not considered a right-wing circuit. Plaintiffs brought the race discrimination claim, alleging they were demoted because of a specific policy. And the mayor testified there was a policy for his administration to reflect the diversity of the city. Race was an important factor, and the training sessions, again, were an important fact here. So I think that brings us to our last example on interview slates.
Yeah, so another common practice we're seeing a lot of is diverse interview slates. So this isn't giving a specific position to anybody, reserving a specific position based on race, but it's saying that you have to interview at least X number of diverse candidates, usually defined based on race and sex and sexual orientation. But you have to interview at least 3 out of 10, or in some cases 5 out of 10 candidates for these positions. And in some cases, it's not just positions, it's opportunities, it's pitches, it's basically anything that can lead to partnership at law firms. An example of this is Mansfield certification. So if you work at a private law firm, you may have heard of this. It's a certification that quite a few major law firms have participated in, and it requires that at least 30% historically underrepresented lawyers are considered for, again, a number of activities that lead to leadership. Now, Title VII, again, is pretty clear that you can't discriminate even in interviewing. It doesn't have to be a current employee. It can be an interviewee as well. But there was some debate in the courts until recently. There was some debate about whether being denied an interview was actually actionable under Title VII. So some courts had said that it wasn't actionable because it wasn't quite enough harm. Other courts had said, well, it seems like probably this will be actionable. This would qualify as an adverse action under Title VII. And last month, the Supreme Court resolved this circuit split and essentially lowered the bar for what's required for a Title VII plaintiff. So the Muldrow case involved a discriminatory transfer. And the court said a Title VII plaintiff only needs to show some injury, and it removed that materiality requirement that some courts had found. So some courts had said that it has to be, a material adverse action, a significant harm, and the Supreme Court said that's nowhere in the statute. So although this didn't deal with interviews specifically, it lowered the bar, making it fairly clear that these diverse interview slates where individuals are being denied opportunities because of their race are going to be actionable. Again, it remains to be seen. This is new law, but I think it'd be very difficult to argue that being denied an interview based on your race would not qualify under Title VII as an adverse action. So it's one of those situations where it's not going to be every time you use a diverse interview slate, but at some point, someone's going to be denied an interview based on race. So again, with Students for Fair Admission saying a benefit provided to some leads to a disadvantage to others, interview slate policies, I think, are going to expose companies to quite a bit of liability going forward.
Do we have time for me to ask a couple of questions of you panelists before we take questions from the audience? I think that people in large part probably agree that diversity in the workplace is a good thing. The court called it commendable in the SFFA case. What actions can employers take to increase diversity without running afoul of the law?
Paul, do you want to take this one, or do you want me to?
Go ahead.
Yeah, so there are quite a few things that employers can do to increase diversity, generally speaking, but they must be race neutral. So if you say, first generation college student or first generation lawyer, unique family background, veterans, things like that. There are a lot of different backgrounds that you could include in a DEI program that wouldn't be based on race. And that's critical because, as SFFA said, judging someone based on their race is qualitatively different from judging them based on another category, another qualification, or a unique background. So some things an employer could do would be, again, like first generation programs, single parent programs, really anything that doesn't expressly qualify or classify someone based on race could achieve diversity in the workplace without engaging in impermissible discrimination.
Shall we see if there are questions from the audience? And I've got a few questions if there are not. Let's see if there are questions from the audience.
Perfect. And thank you guys for that great presentation. This is a reminder to everyone in the audience that the CLE code is in the chat. So you can see that there. It's all caps, all one word, Enforce 2024. Be sure to write that down because you'll need it when you're putting together your certificate of completion later. Also, if you have a question for our panelists here, please put it in the Q&A section at the bottom of the screen, and we will get to that. Starting out with our first question, and I think you touched on this briefly, but does the quota versus something else distinction still matter after SFFA?
Quota versus goal, I take it.
Mm-hmm. Or something else more broadly, if they're more clever in hiding it.
I'm happy to take this one, or Paul, you can jump in if you want, but we've gone back and forth with this a number of times because what's happening is companies are saying, no, this is not a quota. And the reason they say that is quotas are plainly unconstitutional, unlawful. Everyone knows you can't have a quota. So what they're saying is, well, this isn't a quota, this is a target, this is a goal. And the real debate is, is this really a semantic battle or is there an actual difference? I would argue it's just a semantic difference. It's not a material, real difference. When you say we want to have 13% of X race, 10% of another race, 25% of another race, I mean, what difference is that from saying we've reserved 4 out of every 100 spots? It really doesn't seem like a material difference. But that's where a lot of the work is going to be done, I think, on future cases, is figuring out what qualifies as an unlawful quota. In the Missouri Attorney General case that we mentioned, the Attorney General there is saying that a representation goal, meaning a goal that roughly matches population demographics, is an unlawful quota. So we'll see if that's successful in the courts. But again, I think it's just sort of a silly game we're playing, trying to draw the line between targets, goals, and quotas. And that DC Circuit case that Paul mentioned would support my position on that. Do you have anything to add on that? Yeah, we've been debating this.
Right. The only other thing I'd add, and I think this kind of comes up in the distinction between the Republican AG letter and the Democrat AG letter, where the Democrats say race-neutral programs that improve outcomes for all do not run afoul of the law, which again is a very careful, qualified statement that I suspect both groups of AGs would agree with. Race-neutral, improving outcomes for all, that's lawful. Sort of some of the ideas, Sarah, that I think you were just talking about. So maybe there's a theoretical possibility to fit a compositional target within that framework. If your assumption is that by removing all of these if your assumption is we have a lot of non-job related barriers in our company, and if we remove all of them, then we will hit these aspirational goals. Maybe that is some way that you could try to square an aspirational goal with the legal doctrine. But I just think factually that's not going to be the case for most, and maybe that's not going to be the case for most companies. So even if that theoretical possibility exists, I think it's going to be very difficult for a company to fit within it.
Well, perfect. Moving on to our next question. Are there any other cases in the pipeline by other state AGs like the Missouri case against IBM, or cases likely to be brought, and when?
So this is asking us to predict the future. That's tough. So of course, I think only the AGs would know what they're thinking about doing. I would say if they want to sue, they will have no shortage of targets. There are plenty of companies like Starbucks that put these things on their website and then bragged about it and then sort of gave you all the statistical evidence that you would normally have to go into discovery and fight about to get to back it up. So there are companies that have done that. There are companies that have credit agreements where they put racial targets in the credit agreement and said our interest rate will change based on the racial composition of our executives, of our workforce. So that's another category where you could see litigation. So I think it's just a question of how many of these things do the AGs want to file.
Another point.
Oh, go ahead.
Oh, sorry. I was just going to add, like Paul mentioned initially, each attorney general has a different amount of authority with respect to these state level human rights laws. So Missouri has quite a bit of authority, Florida does as well, but the cases being brought could be just slowed if the state attorney generals are required to go through their state administrative process, which is often the case. So each state is different. And again, like we said, not every attorney general can just directly sue. They can often directly file a complaint with their Human Rights Commission, but it has to work itself through the administrative process. So that can be a slowing factor.
Right. Yeah, I completely agree with that, particularly with respect to state law. But most do have parents patriae authority under federal law. So that was, if you look at the Missouri complaint, that's just a state law complaint. But I think they probably could have filed that under parents patriae authority under Title VII as well, and most other AGs could do that. So again, if you're assessing liability from a company perspective, I don't think you can just look at the number of states with direct enforcement authority. I think you probably have to look at any state that might be interested in filing this.
That's a good point. The federal law gives the state attorney generals more power there.
I was thinking back to the DEI programs generally, and since the SFFA decision came out, I've read several articles. I saw one, not in legal journals, but just in the Washington Post had an article about how companies are, I don't remember the exact language, but backing away from their DEI programs and making changes to them, or at least using different language. And I'm wondering what kind of changes that you have seen or noticed companies making to DEI programs, if any.
One thing we're seeing a lot of is, like you mentioned, just language changes. And sometimes they're sort of brazen about it. They say that they don't really care what the Supreme Court said and that they're going to continue with their DEI programs, but call them something else. Another thing I've seen is an expansion of the definition of diversity. So a lot of employers are thinking, I think unwisely, that they can simply add in non-racial classifications in with racial classifications, and then that will solve their problems. I don't think that's going to be a winning strategy because, again, you're still discriminating against some people based on race. But that's another thing we've seen is just that expansion of the definition of diversity. But it's very interesting to see employers basically say that they're going to keep doing what they're doing. I think there's a lot of risk involved in that. I think the smarter employers are making real changes and are walking back these programs that are blatantly racially discriminatory. Those, I think, are going to be the employers that are rewarded with fewer lawsuits.
If you can use Starbucks as a concrete example, they just changed the disclosure in their securities filing about their compensation. It used to have a diversity and sustainability component. They've shifted that component, part of that component, into company profitability, which obviously seems highly relevant to compensation. And then part of that into, I think, what they're calling an objective and subjective assessment of the individual. So, if I were in law enforcement, I would want to know, well, what are these subjective assessments that you're now doing of the individual? Did you, like Sarah was saying, did you take this criteria that you were describing publicly, and did you just sort of move it into this subjective criteria? Obviously, they're under pressure. I mean, this may have been a response to the Florida Attorney General complaint or other heat that they've gotten on these issues.
Do we have other questions from the audience?
Yes, we have quite a few, actually.
Okay, go ahead.
Next question is, what about aiding and abetting liability? For example, what about interest groups that pressure employers to discriminate on the basis of race, sex, etc., particularly proxy advisors or clients who pressure law firms?
So we've looked at this, at least in the context of state laws, and every state law is different. It's not really clear, I think, the quite exactly what the cause of action would look like here. It's something we've looked into because I think there's a good argument that if you're encouraging an entity to discriminate, you should be held liable under an aiding or abetting statute. But again, every state has a different law, and this is sort of a new area. Paul and I have looked into this because it seems plausible, but we haven't concretely seen something like this yet, at least that I'm aware of. Would you agree with that, Paul? I think it doesn't make sense to say that, you know, an employer cannot discriminate, but they could pay someone to do the discriminating for them. I think if that's the claim, the employer is going to lose, but framing that cause of action is going to be a little bit tricky, I think, with the current landscape of the law.
And next question. And Honey Fund versus DeSantis. The 11th Circuit recently held that mandatory DEI training is protected by the First Amendment. The court rejected the SFFA arguments to the contrary. How do you see the 11th Circuit's approach playing more broadly in this area that we are discussing?
So the Honey Fund case is interesting because the state tried to say you can't have any mandatory DEI programming. So when you have a state law that specifically is telling an employer that they can't discuss an issue, that's what that case addressed. I think that's a little bit different than an individual employer here, like the example we cited, an individual employee, excuse me, who is being subject to mandatory DEI that's extremely harassing, that's essentialistic, that's deterministic. The courts have been clear that those kinds of claims are valid. So again, in Honey Fund, you have the state trying to tell employers they can't talk about certain things. That's going to bring a First Amendment challenge. You don't have that same situation when it's an individual employee bringing a hostile work environment claim under Title VII. So I think Honey Fund is a little bit of a separate issue.
There's just no way to say whether this training is good or bad. It depends so much on what's said during the training. And you can have very good licit training on topics, or it could be racial harassment. And unless you get there and critique it from the inside, I don't know how the courts could ever say it's just going to be absolutely not permitted.
Exactly. That's a good point. You know, and the courts have said you can talk about race. It's not illegal to talk about race, but so much depends on how you talk about it. And then what we're seeing with the handful of hostile work environment claims that have survived motions to dismiss is they also include very negative interpersonal interactions, you know, harassing comments by coworkers or supervisors. What I've seen so far, and there's only a handful of these, but they are moving forward, a handful of them are moving forward, is it usually includes something else in addition to these mandatory trainings.
Our next question is, what does this mean for the EEOC requirements that you review your population demographics and list steps that the employer is taking to change disparities between that and your workforce? EEO-1.
Well, I think Sharon's probably the one of the best experts in the country on this, but I think this highlights a tension, Sharon, that you brought up.
It does, and it raises another one. It highlights another one that I didn't mention, and that is Title VII expressly states that it does not require affirmative action. It does not require preferential treatment on account of race because of an imbalance in the number or percentage of persons of any race employed compared to the number of people in the workforce of that race. So Title VII does not require affirmative action. Of course, that's a different question from whether it permits it and the extent to which that may or may not be so. But at the same time, Title VII prohibits legal challenges to consent decrees, many of which contain these racial hiring goals. So it's just interesting that the law doesn't require affirmative action, but often once the EEOC has brought claims against an employer, they're resolved through consent decrees that do have hiring goals. And I don't know of them ever having hiring quotas. I think these are public documents. But they don't have hiring quotas, but they have hiring goals. And then the question comes up, you know, what is the difference? If you're not going to act on those goals, why have them? And if you are going to act on them, how do you do so in a way that doesn't discriminate against anybody who's not the beneficiary of the goal?
Right. And I think another tension is around prohibition on disparate impact and the removal of barriers that don't relate to the job. And so that's how I also view some of this reporting requirements, and you see this in some of the federal contracting regulations as well. That you can't discriminate on race, but if you have some non-job related barrier that's producing a disparate impact, you need to measure that, and you need to remove that non-job related criteria. So that's how I would try to square these things. I don't know if that's the way everyone would see it, but I think it's a potential way.
I'm waiting for people to bring claims of disparate impact based on the college degree requirement. Because I think there are just so many jobs out there, arguably, that don't really require a college degree in order to complete the job, but require them. And then the question is, does that have a disparate impact on people based on race? And I don't know the answers, but I wonder about those issues.
Another issue that we might be seeing coming up too is just how much deference we should give to the EEOC's statements on these, because the Supreme Court recently said agencies don't get the same deference that they've gotten in the past. And so that's going to be in play as well going forward. Mostly open questions here, though.
That's a really interesting point. The EEOC may have to take another look at the statutory language that they've been basing some of this material off of, and make sure that it lines up from a de novo perspective and not just a agency practice perspective.
But, the EEOC was not given substantive rulemaking authority over Title VII. So all of the guidance and guidelines that they have written, it has, I would say it's only had persuasive effect all along, to the extent courts recognize that.
Our next question is, what are your thoughts on school/businesses advertising and celebrating their staff or their classes more diverse? This also happens with sex and regarding women. The Askgrass, I've seen this from my alma mater, and it seems like they're always exhibiting #1 in discrimination cases.
Is this in the employment context or just in schools generally?
I think he's asking
Issue
in
context.
those contexts, but
yeah, it's because they're celebrating the staff, right? So
Mhm.
I think that's how it relates to employment. So they're marketing the school, but they're marketing the school by saying our staff has these racial characteristics, which I think the implication would be that if you're marketing that, then you're probably incorporating it into your hiring decisions somehow.
Mhm.
The law is pretty simple. Race cannot be a factor in making your hiring decisions.
Yeah, and it sounds like, it'd probably depend on discovery, but that would certainly seem to open the door to getting discovery around those hiring practices.
Something we've talked about is pattern and practice discrimination cases that look at sort of the whole environment that an employer has. And if you can point into, it would be in discovery, but if you can say, hey, our employer is continually touting that they hire people of certain races, that could certainly be a factor in favor of a Title VII plaintiff bringing a pattern and practice case.
Our next question is, can you comment on the friction between SFFA and the pressure brought to bear on employers to enhance ESG? I assume he means from people like proxy voters and other factors like that.
Well, I think this is a scenario where companies are going to have to say, we're not going to do things that are unlawful. And they just have to have the courage to say that. And they have to have the backbone to say it. And hopefully the environment is changing around some of these shareholder proposals and engagements, where there's been more light shed on the practice. And when a company says, hey, you're asking us to do something illegal, then hopefully the clients of those asset managers and the clients of those proxy advisors would say, hey, knock it off. This is not why we delegated you this authority to go around and tell companies to do illegal things.
A few more questions before we have to wrap up at the top of the hour. What are the EEOC's options to take action regarding these policies in a new presidential administration?
I'd defer to Sharon on that for sure.
Say the question, what are the options? The EEOC's options to do what?
To take action on these policies in a new presidential administration.
You know, there's a diversity of opinion even at the EEOC on these issues. I mean, I've heard people at the EEOC, people that I have great respect for, talk about the fact that there's no reverse race discrimination. There's only race discrimination. You simply can't discriminate based on race. There are other people who are very sensitive and in favor of the DEI programs and would be in favor of things that I think others would consider race discrimination. So, you know, that's one thing to keep in mind. People have different views everywhere, including there. The policymakers are the commissioners, and the commissioners are appointed for 5-year terms. If my memory serves me correctly, I think that's right. And I don't think any president has ever removed a commissioner before their term is up. So when an administration changes, who knows if that will happen, but when an administration changes, it's sometimes a very long delay before there's any change at the EEOC, because the commissioners, you know, no new commissioners are appointed until other people cycle off. And as we've seen in the current administration and the former one, it took a very long time to even get a general counsel appointed. So I say that all that to say, don't expect major changes of any sort quickly with a change of administration at the agency.
Time probably for one more question here. How do we recognize that groups of people may have different needs or access to opportunities? For example, women have often been left out of the quote unquote boys club type of networking. So networking groups specifically for women try to fix that. How can companies try to address and fix those sorts of issues? They're
doing so with these employee resource groups. I mean, I don't know that they're employee resource groups for women, but there may be other groups that allow women to address these issues. But I think that as long as employee resource groups are non-discriminatory and anybody's allowed to set them up for their employee interests to talk about things and how they can help themselves and other people in their group with similar needs, those things are acceptable. And I think those are going to continue to exist. That's the primary way.
I think companies could also attack the problem that's being described. I mean, that sounds like a barrier that's not related to job criteria at all.
True.
If there's some sort of networking that's happening at the company that's only appealing or available to certain groups, then that's a significant problem. And it makes sense to address that cause rather than trying to create a separate group that might not include the key leadership or the key executives, and may not solve the problem after all.
That's a very good point. And the other way that change usually happens is that people sue. People bring EEOC charges, people bring lawsuits, and companies learn that way. And if sometimes I think there is just ignorant discrimination. People don't realize they're doing it, but they are doing it in ways that hurt certain protected classes. And that's why we need people to keep bringing claims and sue as appropriate.
Does anyone here have any final closing thoughts before we call it?
I'll just say, I think it's an exciting time in this specific area. There's a lot of developments happening every day. And I think most of our subject matter here is questions rather than answers. So we'll see what happens with the courts.
And I think times like this just make us go back to the basics and think, what are the basics? And the basics are, in the United States, we don't permit discrimination based on race in the workplace. And we just have to return to that and remember it and enforce it.
Well, on behalf of the Federalist Society and the In-House Counsel Network, I want to thank our experts for the benefit of their valuable time and expertise today. And I wanted to thank our audience for joining us and participating especially with those great questions. I have just placed the CLE code one last time in the chat, so please write that down. You'll need it for your certificate later. And we welcome listener feedback by email at info@fed-soc.org. And if you have questions particularly relating to CLE, that would be cle@fedsoc.org. As always, keep an eye on our website and your emails for announcement about upcoming webinars and an upcoming IHC conference, which we'll be hosting in Nashville on September 27th. Thank you all for joining us today. We are adjourned.